Okay, in all my videos, some people think I'm a little bit repetitive when I mention in the public interest, maintain the public trust. That is actually the legal responsibility. That's law, okay, for all people in public service, okay, especially when it comes to lawyers and judges. Okay, they must do what's in the public interest and maintain the public trust. So let's get into that because I'm gonna read that to you, but I want you to understand what the preamble is all about. The preamble, the rules of professional conduct, outlines the fundamental responsibilities of lawyers as representatives of clients, officers of the legal system, and public citizens. It emphasizes the importance of upholding the integrity of the legal system, ensuring equal access to justice, and maintaining the independence of the legal profession. Lawyers are entrusted with a public trust that must act with competence, diligence, and integrity in all professional functions. Okay, lawyers are entrusted with the public trust. Okay, now remember, I told you about the public trust doctrine. The legal institutions and anybody that works within them are all officers of the court, and the court is part of the public trust. Okay, so trust fund babies understand that they're operating in the public trust. Okay. Okay, lawyers are entrusted with a public trust, meaning also as you having confidence in them, and must act with competence, diligence. Remember, diligence. They got to get shit done quick, fast, and in a hurry. And integrity in all their professional functions. Key responsibility of lawyers, as outlined in the preamble, as a representative of clients, lawyers must advocate for their clients' interest, provide informed legal advice. Remember, I was telling you, in order for a case to proceed in court, they must obtain informed consent. In order for you to give informed consent, you must have reasonable knowledge to make an informed decision to give informed consent. You not knowing anything I'm telling you is a lack of informed consent. Okay, so they're breaking the law. As a representative of clients, lawyers must advocate for the client's interests, provide informed legal advice, and ensure their clients understand their rights and obligations. As an officer of the legal systems, lawyers must uphold the integrity of the legal systems, comply with all laws and rules, and demonstrate respect for the court and its process. As a public citizen, a lawyer have a responsibility to improve the legal system, promote access to justice, and contribute to the public good. This includes in participating in pro bono legal services, promoting legal education, like what I'm doing. If you watched any of my videos, you should really watch them all. They're all quite informative, and I'm just trying to teach you what you should know so that way you can have some remnants of a fair trial. And advocating reforms that benefit the public. Okay, this includes participating in pro bono legal services, promoting legal education, and advocating for reforms that benefit benefit the public. And I was talking to somebody about this. I wish that I could go to like my old stomping grounds where I went to high school, Kelly High School in Chicago, Illinois, and teach a class. I've been doing this for free since 1979, so it's not like I'm going to charge an arm and a leg. But I would love to teach the younger generation, going from high school to prison, I've been there. If I would have known what I know now back then, I would have never went to prison. I would have had a fair trial. Due process would have existed. I would have had competent, effective assistance of counsel. But I didn't. I had ineffective assistance of counsel. Uh, Failed to abide by the rules of professional conduct, any form or fashion, and that's misconduct. And multiple counts of misconduct, mind you. And since reporting misconduct is mandatory in the rules of professional conduct, code of judicial conduct, I was a victim of prosecutorial misconduct and judicial misconduct because neither the prosecutor or the judge reported my attorney for violations of the rules of professional conduct. And failure to report misconduct is misconduct. So it's impossible just to violate one rule in the rules of professional conduct. And when you violate the rules of professional conduct, you violate the code of judicial conduct, and it's impossible to violate just one code. And when you violate the code of judicial conduct, the rules are being violated as well because nobody's reporting misconduct. So that's up to you. Promoting legal education and advocating for reforms that benefit the public. You know, I would really love to. I mean, like, just make it a law where kids have to learn what due process is, what a fair trial is, what effective assistance of counsel is, you know, the limitations on the quick and speedy trial, which is only 90 days, and people are sitting in prison because they lack that quick and speedy trial. And if they didn't have a quick and speedy trial, they didn't have effective assistance of counsel. If they didn't have effective assistance of counsel, they didn't have a fair trial. If they didn't have a trial, due process did not exist. Okay, maintaining independence. The preamble recognizes that the independent legal profession is crucial for preserving government under law and challenging abuses of legal authority. Lawyers should also be responsible for the observance of the rules of professional conduct by other lawyers. Promoting the public interest. The legal profession has a responsibility to ensure that its obligations are conceived in the public interest and not in furtherance or self-interest concerns. See, that's not just for politicians, that's for lawyers and judges too. Remember, the rules of professional conduct, as well as the code of judicial conduct, are the legal responsibilities of all judges and lawyers in every court of law. The lawyer's responsibilities, every lawyer is responsible for observing the rules of professional conduct and aiding and securing their observance by other lawyers. So, it tells you right there, reporting misconduct is mandatory. We haven't even gotten to the rules where it says it is. Reporting misconduct is mandatory. Failure to report misconduct is misconduct. Model rules professional. I'm using the American Bar Association because it's the model rules of professional conduct, which is a standard set forth for every state. And they can build on it, enhance it, you know, give it strength. It's there to make sure there's no legal loopholes. There's no such thing. There's no such thing as a legal loophole. It's just a loophole, a backdoor. It's screen door on the submarine. Okay, there shouldn't be any legal loopholes. I mean, it can easily be. I've talked to people with lawyers that got divorced and had a clad, tight, sealed prenup. And I mean, so I guess we're gonna have to get the prenup guys in there, okay? Model rules of professional conduct, preamble, scope, a lawyer's responsibility. The lawyer is a member of the legal profession, is a representative of clients, is officer of the legal system, and a public citizen having special responsibilities for the quality of justice. As a representative of clients, the lawyer performs various functions. As an advisor, the lawyer provides client with informed understanding of the client's legal rights and obligations and explains their practical implications. As an advocate, a lawyer zealously asserts the client's position under the rule of the advisory system. As a negotiator, lawyers shall seek results advantageous to the client but consistent with requirements of honest dealings with others. As an evaluator, a lawyer acts by examining clients' affairs and reporting about them to their clients or to others. In addition to these representative functions, a lawyer may serve as a third-party, neutral, or non-representational role in helping parties to resolve or dispute matter or other matters. Some of these rules apply directly to lawyers who have served third-party neutrals Okay, in all professional functions, a lawyer should be competent, prompt, and diligent. A lawyer shall maintain communication with the client concerning the representation. Communication is one of the rules. All these are laws, people. Okay? All these are laws. A lawyer should keep in confidence information relating to representation of a client except so far as disclosed is required by permitted by the rules of professional conduct or other law. A lawyer's conduct should conform to the requirements of law, both in professional services to clients in a lawyer's business and personal affairs. And personal affairs. That means outside the courtroom as well, okay? A lawyer should use the lawyer's procedures only for legitimate purposes and not to harass or intimidate others, like filing slap suits. A lawyer should demonstrate respect for the legal system and for those who serve it, including judges, other lawyers, and public officials. Remember, I was telling you about, this applies to public officials as well, and not all public officials, but the rich ones have lawyers. So if they're breaking the law, it's the lawyer's duty to tell them, hey, we can't do that. That's not in the public interest. This is not how we maintain the public trust. Okay, other lawyers, while it's a lawyer's duty when necessary to challenge the rectitude of official action, it's also a lawyer's duty to uphold the legal process. As a public citizen, a lawyer should seek improvement of the law's access to the legal system, the administration of justice, and the quality of service rendered by the legal profession as a member of a learned profession. A lawyer shall cultivate knowledge of law beyond its use for clients, employ that knowledge in reform of the law, and work to strengthen legal education. That's why it's so expensive to go to law school. Nobody's doing that. In addition, a lawyer should further the public's understanding of the confidence in the rule of law and the justice system, because legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority. Lawyers should be mindful of deficiencies in the administration of justice and the fact that the poor and sometimes persons who are not poor cannot afford adequate legal assistance. Therefore, all lawyers should devote professional time and resources and use civil influence to ensure equal access to our system of justice for all those who become of economic or social barriers cannot afford secure, adequate legal counsel. A lawyer should aid in the legal profession in pursuing these objectives, and should help the bar regulate itself in the public interest. Okay, remember I keep telling you they got to do what's in the public interest, and who's the public? We the people. That's what I'm all about. That's what legal reform is all about. A we the people thing, trying to teach you what you should know before you ever talk to a lawyer or step in front of a judge. Okay, many of a lawyer's professional responsibilities are prescribed in the rules of professional conduct, as well as substantive and procedural law. However, a lawyer should also be guided by personal conscience and professional peers. Lawyers should strive to obtain the highest level of skill to improve the law in the legal profession and to exemplify the legal profession's ideals of public service. Okay, so remember, everybody that's a lawyer is a public servant. A lot of lawyers, I've been at it with them before until I bring out the rule of professional conduct. I used to carry copies with me. And I would have to remind them, no matter who you work for, you're a public servant. You are legally required to do what's in the public interest above all. This is how you maintain the public trust. Okay, so you're going to have to remind them. I can't be there for everybody. I'm one person here at Legal Reform, and I'm doing my best to be as formative as possible to as many people as possible. Okay, a lawyer's responsibilities as a representative of a client, officer, the legal system, and a public citizen are usually harmonious. Thus, when an opposing party is well represented, a lawyer can be a zealous advocate on behalf of a client and at the same time assure that justice is being done. So also a lawyer can be sure that preserving client confidence only serves the public interest because people are more likely to seek legal advice and thereby heed their legal obligations when they are known communications will be private. In the nature of law practice, however, conflicting responsibilities are encountered. Virtually all difficult ethical problems arise from conflict between a lawyer's responsibilities to clients, to the legal system, and a lawyer's own interest in remaining an ethical person while earning a satisfactory living. Remember, any violation of the rules of professional conduct, whether it's in the preamble, the scope, or the rules itself, is a violation. So they're allowed to make a satisfactory living, but they are not allowed to violate the rules of professional conduct or the code of judicial conduct in doing so. The rules of professional conduct often prescribe terms for resolving such conflicts. Within the framework of these rules, however, many difficult issues of professional discretion can arise. Such issues must be resolved through exercise of sensitive profession and moral judgment, guided by basic principles underlying the rules. These principles include a lawyer's obligation zealously to protect and pursue the client's legitimate interest. These principles include a lawyer's obligation zealously to protect and pursue a client's legitimate interest within the bounds of the law, while maintaining a professional, courteous, and civil attitude toward all persons involved in the legal system. Now, this is where it gets good. The legal profession is largely self-governing, although other professions also have been granted powers of self-government. The legal profession is unique in respect because of the close relationship with the profession and the process of the government and law enforcement. This connection is manifested in the fact that ultimate authority over the legal profession is versed largely in the courts. To the extent that all lawyers meet their obligations of their professional calling, the occasion for government obligation is obviated. Self-regulation helps maintain the legal profession independent from the government domination. An independent legal profession is an important force in preserving government under law. For abuse of legal authority is more readily challenged by a profession whose members are not dependent on government for the right to practice. I hope you heard that right. And if you didn't, read it your damn self. Sorry, I don't mean to get mad, but a lot of people like to argue the law with me. How can they argue the written law? I've never argued the written law. When it comes to the written law, I go by the letter, word for word, as required by the letter of the law. That's a mandate in interpreting the law. So I wouldn't read to you anything other than what is written. It's illegal. It's illegal to say this doesn't mean what you think it means, which quite a few people in the legal profession will tell you. So when it comes to any written law, whether it be the rules, professional, the code of judicial conduct, whether it be a union contract, if you're in a union and you have a contract, I went through this. I used to carry the union handbook with me, which was a contract. And I used to get all kinds of threats from foremen and plant supervisors and people in the office. And I always took out the union contract, the handbook. And they always told me, that doesn't mean what you think it means. See, our interpretation goes like this. And whether it was the union or the company, and they did bring in some lawyers, when they tried to explain that, I silenced them all when I cited the letter of the law. That's to avoid the letter of the law. I says, can you put that in writing for me? And they wouldn't do it. I said, do you mind? I have a video camera. I want to record this. And everybody quit telling me what what they thought it meant, their version of what it meant to them. Okay, the lawyers just got up and walked out. They didn't argue. Neglect of these responsibilities compromises the independence of profession and the public interest which it serves. Okay? The public interest, the interest of we the people, the best interest. And remember, before they can do anything, like right now they're trying to sell off some public lands, the public lands, that's in the public trust, just like the legal system. You need, and they need to get informed consent from the public. They are the trustees of the public trust. That's literally pillaging the public trust. Read the public trust doctrine. Google list. I forgot what I put. Entities of the public trust doctrine. Who's included in the public trust doctrine? What government agencies, and they'll tell you them all. Anybody that takes an oath to the Constitution is a trustee of the public trust. And as far as, you're just used to them doing what they want, like legal bribery, no such thing. If you read the basic obligations, public service, you would know that's illegal, but it was written right after the Constitution. That's an old law, old bunch of laws that are being broken. Lawyers play a vital role in preservation of society. Fulfillment in this role requires an understanding by lawyers of the relationship to the legal system. The rules of professional conduct, which properly applied, serve to define that relationship. Okay, remember I told you about informed consent? It used to be right there, before scope and after the preamble. It was a paragraph, and just to give you a brief synopsis, what it said informed consent must be obtained before the legal process can proceed, something like that. In order to obtain informed consent, one must give reasonable knowledge so that person can make an informed decision in order to give informed consent. So you need reasonable knowledge to make an informed decision, and that would be knowing the judges and lawyers' legal obligations to you in a court of law. Not just to you in a court of law, but any law made. Every law made must be in the public interest. Say, for instance, the tax codes, they must be in the public interest. The Constitution was written to serve the needs of the many, not the greed of the few. And that those tax codes are being written for the greed of the few. It's a very simple law. Like I told you, it says in here, they must do what's in the public interest and maintain the public trust. The rules of professional conduct are rules for reason. They should be interpreted with reference to the purpose of the legal representation and the law itself. Some of these rules are imperative, cast in terms shall or shall not. These define proper conduct for the purpose of professional discipline. Okay, the rules, purpose, a larger legal context, shaping the lawyer's role. This context includes court rules, statutes relating to matters, licensure laws defining specific obligations. Compliance with the rules are, as with all laws in an open society. See, I've had arguments with lawyers in front of their clients, and they would get mad at me, and they always deny that these were laws, but these are laws. Compliance with the rules, as with all laws in an open society, depend primarily upon understanding and voluntarily compliance. Secondarily, upon reinforcement by peer and public option are finally when necessary upon enforcement. Okay, but you get the gist of that. Okay. Uh, so, uh, okay. Rules of professional conduct complaint form. File a complaint against a lawyer for violating the rules. Professional conduct, you should typically start by contacting your local bar associate or state's disciplinary authority. These organizations are responsible for investigating complaints and addressing violations of ethical rules. So remember, violating the rules of professional conduct is also violating code of ethics. And what's that called? Department of Ethics or something. But look up where to file for ethics violations, and that'll take you directly where to file for that too. State of Bar Association, identifying the governing body, state bar associations. Many bar associations have their own websites, online forums, attorney registration, disciplinary commission. So you can get one there. And a lot of people I talked to, they said when they went to their state disciplinary commission, I've talked to people in almost every state, and they always tell them, no, first you got to do this, first you got to do this, do that, and no, just find the form. See, so misconduct. So if you cite something for misconduct, yeah, remember reporting professional misconduct. A lawyer who knows another lawyer has committed a violation of rules of conduct that raises a substantial question. Okay, so I told you reporting misconduct is mandatory, not just by the opposing party or anybody in the courtroom, anybody that even has knowledge of any misconduct. And you don't have to be in the same state. They could see it on television. If anybody has any knowledge that any lawyer or any judge violates the rules of professional conduct or the code of judicial conduct, is legally obligated to report them. Okay. Lawyers argue, well, I don't have to. I'm not licensed to practice in that state. But the rules, state and federal, clearly state reporting misconduct is mandatory. It doesn't say except. No, it's just mandatory. Okay, and since the other side didn't report your lawyer's misconduct for violating the rules, and they all do, communication. I've rarely seen lawyers communicate, diligence, meaning getting things done quick, fast, and all right. Expedite litigation, that's mandatory. That doesn't happen. They're supposed to come in court ready, prepared, and they don't. When they come in for that probable cause hearing, they must come with everything available. Anything the state's accusing them, they must have, that's discovery. They're supposed to supply it to your lawyer. Your lawyer should have it before he walks in that courtroom to defend your case. And most lawyers won't even ask for a probable cause hearing. They like to go on to a preliminary hearing, and that moves on to trial. And constant continuances. How is that expediting litigation? How is that being diligent? Failure to expedite litigation, that's a lack of competence. They don't even communicate to you why. Okay, so when you cite your attorney for ineffective assistance of counsel because they break all the rules, no matter what court you're in, probate court, guardianship, child custody court, whether they're taking your kids from you or kids, if they're taking you from your parents. And listen, if you understand anything I read, you're going to understand everything I read, in all my other videos. So learn how to defend yourself, I started when I was 10 years old. Oh, let me go back. Okay, let's see, I already got that one. Word file. Okay. Okay, to file a complaint against a lawyer for violating the rules of professional conduct. Okay, I already went through that one. Oh, here it is. There's a lot of other things I wanted to talk to you about. Okay. Okay, people didn't believe me about this, but, okay, like I said, when you cite your lawyer for ineffective assistance of counsel, most of the time, actually all the time, they'll basically rubber stamp it. They'll say, well, you need exculpatory evidence. Well, you don't actually. I got a guy out of prison, from Centralia, Illinois in 1991. I think he was Cuban or Puerto Rican, lived on the north side of Chicago. I got him out of prison on a late notice of appeal. His lawyer took his money, $7,500, and didn't file the appeal. So his wife tried contacting the lawyer. He was trying from prison. He couldn't get a hold of him. When his wife finally got a hold of him, he said it was too late. It was too late, his time surpassed, I think he had 30 days. And it was already 2 weeks past that. So his wife went to see him. She was crying. He was crying. The kid was crying because they were crying. So I seen him later, and I said, why don't you just file a late notice of appeal? I said, what do you mean? He says, can I get a lawyer to do that? So you got money? He says, no. Well, the lawyer took money. I said, you'll never get a lawyer to do that. Plus, the court won't accept it. They'll accept it if you file it. So I filed it on these grounds: ineffective assistance of counsel, prosecutorial misconduct, and judicial misconduct, which shows this: a conspiracy against rights under the color of law known as 18 U.S.C. 241 and U.S.C. 214 refers crime of two or more individuals conspire to interfere with an individual's civil right, or where a person acting under authority of government deprives someone of their rights. It's about using government power to violate constitutional rights. That's called under the color of law. You think it's legal because they did it to you, but it's not actually legal because they violated your constitutional rights to do what they did. Okay? So that's a conspiracy against rights under the color of law. And that's against the law. Okay? So you can read up on that. Deprivation of rights under the color of law. If your lawyer is not abiding by the rules of professional conduct, that's ineffective assistance of counsel. And that's violating not just your constitutional right, but his constitutional duty. Every lawyer has a constitutional duty to be effective assistance of counsel, and that's to abide by and enforce or report, so it is enforced, any violations of said rules of professional conduct. It's illegal. It's illegal. That's violating the oath, and punishment for violating the oath is fines, fines, removal from public service, and incarceration. Okay, they don't mention what I mentioned to you, okay, about your lawyer conspiring with the other side conspiring with your lawyer and the judge. Nobody's abiding by the rules of professional conduct and the code of judicial conduct. And it's up to you to read them. I'd read them to you, but each one will take a couple hours. You know. Color of law. Section 242 requires the action to be done under the color of law, meaning that the person is acting under the authority of government entity. Section 241 can apply to private actors if they conspire with government officials, if they use government power to interfere with rights. Okay. See, so these are a lot of things I'm just trying to get you to understand. See, it's their constitutional duty to do everything. In all my videos that I talk to you about, everything, and I'm telling you a lot of stuff they aren't doing. These are your public servants. Biting the hand that feeds them far too many times for far too long. So if you learn these laws and learn to use them and where to use them, I mean, you call your public officials, talk to them about the basic obligations of public service. And you reading them, that'll tell you, all this crap you think is legal bribery isn't legal. You're just, as a country, we're just so used to them doing things they want. Our public servants, all of them, doing things the way they want. They're above the law. Our politicians replaced the monarchy. I mean, monarchy was above the law. When I read the Magna Carta and then the Constitution and, I mean, the U.S. Supreme Court not having a code of conduct was in the interest of the bar. That was not in the public interest. Okay, specific intent. Section 242 requires specific intent to deprive someone of their rights, while Section 241 focus on conspiracy and intent to injure. Listen, people, I talked to people in child court. They were going through child court custody, and they were told that they don't, we're not going to give you a lawyer. The Constitution quite clearly states that, if they're depriving you of life, liberty, and pursuit of happiness, they got it. Before they do that, they got to give you a lawyer. Penalties, both are felonies. Section 242, which involves direct deprivation of rights, can result in harsher penalties, including life imprisonment or even death penalty in certain cases. And, I mean, I seen a video of somebody that found exculpatory evidence, and they were trying to get this guy out of prison, and they were trying to get it back in court, and they got a lawyer costing a lot of money, and Rule 3.8 special rules of the prosecutor clearly stipulates that if a prosecutor becomes aware of a wrongful conviction, it's their legal obligation, and they have the legal authority to bring that case back to court for exoneration. It's their job. If you read the rules of professional conduct, that's Rule 3.8 special responsibilities of the prosecutor. Okay, people, remember these are civil rights divisions. There's plenty of agencies that have a civil rights division. If you want to Google list of government agencies that have civil rights divisions, you should come up with, I think, at least 7, 9, maybe 10. and file with each accordingly, okay? The FBI, DOJ, DOI, you'll find file everywhere, okay? Not just with your judicial, where you report for misconduct against the judges and lawyers in your state. All you got to do is where to file for violations. Well, once you Google the rules of professional conduct or the code of judicial conduct, your state issue will come up, and then you put where to file a complaint, and it'll tell you exactly where, and that usually goes to your state Supreme Court. Okay, so if you just cite ineffective assistance to counsel, it'll more than likely be rubber stamp. But if you cite ineffective assistance to counsel, all the rules they broke, which will be plentiful, you prove ineffective. You don't even need exculpatory evidence. You just need the rules. And it's easy to prove. It's easy to prove. All you got to do is read them. You'll find them as enlightening as you're finding this video, I hope. And reporting misconduct is mandatory, so the state's attorney didn't report your lawyer. They know, everybody knows the rules of professional. All lawyers and judges know the rules and the codes. And they're specific. Their job is to make sure all that happens. And if it doesn't happen, it's mandatory to report. Failure to report is misconduct. But see, everybody in the legal system knows it's happening. Nobody's going to do nothing, so it's up to you. I've been doing this, going at it with them since I found the rules and the codes back in '79. Trying to educate as many people as possible, but people get mad at me. What do you know? You're not a lawyer. People think I have to be a lawyer to read the law, understand the law. Listen, you're understanding everything I said. And you're probably reading as I'm scrolling. Okay. There's a lot of different places you can file with and look things up. Okay. I'm just trying to open your eyes. Everything and anything I said is not a matter of opinion. It's a matter of fact. And I don't want you to believe me. I want you to believe your eyes. With every hope that when I open your eyes, I opened your mind. When I open your mind, I open your heart as an open mind. And everybody I talk to can use this defense, no matter what court you're in. I've been telling people for I don't know how many years, no matter where you go, no matter what court you're in, no matter what law that's being written, there's always a conspiracy against rights under the color of law. Look what they did to the public trust doctrine. Schools, public schools used to be in there. College used to be free. But they decided to privatize it. They want to privatize Social Security. They privatized the healthcare system. If we had some honest politicians, they would put the public trust, everything back in the public trust. People say it's socialism, but it's the public trust doctrine. In every democracy, this is law. People call Europe socialist because they have a tendency to follow the law more than our politicians, especially when it comes to the public trust doctrine. Why do you think they got so many railroads and, public transportation? And, they're doing what's in the public interest. And all the land, that's part of the public trust, so they're using public land. So what are they going to do, sell it back to the public? No, that makes no sense. No. And that's why their taxes are higher, because they're busy built, and they have a lot of stuff that's, you got to admit, it's pretty damn cool. Okay, deprivation of rights. What does color mean? Okay, people, I'm just doing my best to get you interested, okay? Remember, when you cite ineffective assistance of counsel, a lot of people tell me, they get mad at me because, no, lawyers are honest, they don't lie. Judges are honest. I've seen judges make verdicts despite the law, setting a new precedent, as they call it. But how can it be a new precedent when it violates the law, especially when it's not in the public interest? People, come on, the you want to change the tax system. Refer to the public trust doctrine. Refer to the Constitution and who was written, and especially refer to the public interest and maintaining the public trust. Okay, call your politicians, talk to every lawyer and judge out there. Why aren't you doing your job? Do your job. Do your job. Remind them. When it comes to we the people, where the flame is dying, we come to rekindle it. Thank you. Good night. Peace be with you.